Right. So we've got two of our presenters in. Let's see about getting the third. And I guess while we're waiting for Steph to join, we can, excuse me, have a very brief conversation about kind of the topic of today. So generally, excuse me, today we're going to be talking about cross-border issues that we see with powers of attorney. We kind of see a lot of different stuff. Um, and certainly it's interesting, but the reality is, when people have these powers of attorney, it's super important that these powers of attorney be honored because they set out who's supposed to be handling their affairs kind of broadly. Today with us, we have Ben Young. Um, Ben is our resident estate planning attorney in Rock Island. My name is James Greenwood. I am a estate planning attorney. I have offices in Rock Island, and I also service the Chicago area. With us, in addition to the two of us, we have Steph Iasiello. Steph is a Georgia attorney based in Atlanta in our Atlanta office. So thank you very much, guys, for joining me on this call. I know that you guys have busy schedules, and Steph has a busy court schedule as well. So, given that, I appreciate the time. So today we're just talking about these cross-border issues, powers of attorney. What is a power of attorney? Kind of, let's start off with the basics. What's a power of attorney? What does somebody gain when they execute that power of attorney? Maybe we can move on to questions about, hey, what happens if I draft a power of attorney in one state and then drag that over somewhere else? And then what happens if I, as a resident of state A, move to state B? Can I execute one there? And what are potential problems that can crop up as a result of that? And I think those are the big pieces, but we can certainly talk at length about any one of those things. And we should probably also, one of the things that's really come up is for some of our clients is this Obergefell reconsideration that might be coming up, and we can talk a little bit about that. And we can maybe also address powers of attorney for people who have kids going off to school. I think that that could be a great opportunity. So with that being said, Ben, go ahead and if you want to do the introduction here, what the heck is a power of attorney? Why do I need one?
Yeah. So what a power of attorney is it's a legal document allowing one person to authorize somebody else to make decisions on their behalf. So most states, now again, keep in mind every state has their own rules deciding what's going to happen with a power of attorney. But what there typically is there's two types. One is a financial or a property power of attorney, and the other is a healthcare power of attorney or a medical power of attorney. So again, every single state has their own law that's going to regulate that, deciding on how it's going to be a validly executed document, what powers you can grant, all these different things that are wrapped within each state's individual law. So it's drastically important that one power of attorney that may be valid in Illinois isn't going to be in Georgia or Florida or something along those lines if you don't have the right number of witnesses, notaries, all these different things. So it's incredibly important to make sure that the state you're living in is going to honor that power of attorney you've drafted.
Absolutely. Now, when we talk about powers of attorney, we generally talk about a couple of different flavors, but and I will say, Illinois has a weird one, but we call it something else. We call it a short-term guardianship form, and really what that is it's a souped-up power of attorney for care for children. But there's also what are the two kinds that we primarily deal with when we're dealing with estate planning?
Well, we deal with, like I mentioned, the financial power of attorney and then the medical power of attorney. So, at least in the eyes of Illinois, what they do is they look at any and all decisions that you make on a daily basis fit into one of those two categories. The way I always phrase it with my clients is if it has to do with your person, that's the healthcare or the medical power of attorney. If it has to do with anything else, it's that financial or the property power of attorney. And I keep flipping those terms just because they're used interchangeably. They go back and forth whether that's medical or healthcare or a financial or property. But between those two categories, at least in Illinois, that covers any and all decisions that can be made for a person.
Right. And Steph, does Georgia have the same kind of division of powers, medical and medical, personal, and financial property?
Yes.
Okay. And and I guess, when we have powers of attorney in uh, that we see kind of drafted in one state, and we get a lot of cross-border work on our Rock Island office because we're right next to Iowa. I know that we generally don't have many problems drafting in one state or the other, and the other state honoring it, at least in the region where we're at. Um, Most of the time, I will say, one of the big issues that we've had is large financial institutions talking through and accepting these powers of attorney as they go on. Um, so when we have these issues, I think one of the issues that I've seen before is where somebody takes an Illinois power of attorney, maybe they take it to an Iowa financial institution, and there's a gap there. So powers of attorney, let's talk about drafting in one state, and let's turn to this question of what happens when we draft it in one state and we bring it over to the next, right? You know, um, I mean, and I guess Steph, what's your have you ever dealt with a foreign, we'll call it foreign, but a power of attorney from another state coming into Georgia? You haven't seen that? Okay, well, Steph, we'll ask Ben to
No.
handle
Yeah. Being
that.
on the border, we see it a lot. So again, I look at this from saying there's what they call the legal approach to things, and then there's the practical approach. So what happens is everybody in Illinois wants to see the Illinois form if somebody comes in. Where in Iowa, they want to see the Iowa form. So usually what ends up happening is as soon as you show up with the different states form, it's got to go up the chain somewhere to have somebody that's going to say, "Oh yeah, that's okay. We can honor that." Because the way the law works is as long as it was validly executed, where it was executed, when it was executed, it is supposed to be valid in any state you take it to. Okay. But does that actually happen? Because we live in a world where everybody lives in kind of cover your butt law, where what they're going to do is say they're much more willing to get sued for denying using a power of attorney than they are for accepting it. So what they would much rather do is say, well, this one isn't good. Go get a different one. Or one of my favorite things I hear from all of these companies and places is fill out our form. And we get that a lot is, well, we're not used to seeing that power of attorney. So now all of a sudden you're stuck in this weird limbo stage of, is my power of attorney going to be accepted even though it's 100% valid? Is it going to actually be accepted by the company I'm trying to use it for just because it looks different? That's one of the big things that happens.
Yeah. And I will say, we have definitely seen a fair amount of that, especially again, large financial institutions really love their own forms. And it can become a real problem if somebody is disabled or incapacitated. Maybe they're not available to sign that form. Maybe they're either in the hospital or maybe they have sort of some sort of cognitive decay going on, right? Alzheimer's, dementia, something like that, right? So when we have those types of issues, it can be really challenging. And we don't see a ton of issues, coming cross border again in this particular area, but we do see a few, and usually it's again large financial institutions that we see that with. Now let's play devil's advocate here. Um, can I cross the state border and decide to execute a Illinois form, if I live in Iowa? Is that allowed? Um, I and Ben, you can go ahead and
Yeah,
answer
no,
that if
no,
you'd like, or
that is allowed, but what you're doing is you're subjecting yourself to that state's laws. It kind of comes back to what I said earlier. It has to be validly executed where you executed it, when you executed it. So if you think about it, if you're running over to Illinois as an Iowa resident, well, they have different requirements for what makes a valid power of attorney. But if when you're in Illinois, even though you're an Iowa resident, you follow all of Illinois' rules, it is valid. But again, you're now subjecting yourself to the laws of the state of Illinois as opposed to the laws of Iowa.
Absolutely. And I will
So
say, go ahead.
I think a question for both of you. So if someone is in a position where they have someone who has some sort of cognitive incapacity and they're getting pushback from like a financial institution about using this power of attorney, like what would you guys suggest that they do in that instance?
One thing we do a lot of now is, so one of the biggest pushbacks we see is usually based on the age of the power of attorney, not necessarily where it's from, but this can, again, it can kind of help ease the fears of a financial institution. Is there's a document called the certification of the power of attorney, where the attorney can actually sign off and say, yes, this is a valid power of attorney, and I'm giving my opinion that it's still valid. A lot of times that kind of greases the gears and gets things moving. But it's not a guarantee. It's definitely not.
Yeah. And just as a note, in our Illinois documents, we actually have that certification as part of our document now. We've integrated that fully because of the notes, and I think, I don't know, if we do that in Georgia as well. We do.
There's an agent certification. It's not something I sign off on, but it's something the agent acknowledges at the time that
Yeah, and so what we do is we actually have a attorney certification up here where we say, hey, this thing was validly executed when it was executed. So, and I will say, one of the interesting things about Illinois, one of the unique points of law is you can electronically execute powers of attorney here. And those electronic execution standards are essentially, somebody theoretically could reach into the state of Illinois, ask us to execute an Illinois power of attorney in any of the 50 states, theoretically. And so as long as they were willing to subject themselves to that Illinois law and we had an electronic notary, we could theoretically execute one, and that would be potentially enforceable. So it creates this whole electronic execution mode creates some interesting issues that can crop up. And some of the obvious ones are, what happens if somebody creates a power of attorney, that's valid in a state, but maybe there's another power of attorney out there, that another agency that's not revoked. I mean, that typically, that's something that I've seen a couple of times now, where there's an outstanding agency, the old power of attorney wasn't properly revoked because they've changed states, and the state A the old state had a provision that said, hey, you have to do X, Y, or Z to revoke this old power of attorney. And we ended up having an interesting time when we went to access financial institutions and other things, because they were understandably confused because there were multiple agents floating around, all of whom had valid agencies established. Thankfully, I wasn't the one who dealt with that particular issue, but the creation of those. But we did have some interesting times dealing with it after the fact. Other things that I have seen is there might be different standards for capacity. Some states have looser standards for capacity with whether or not somebody's able to generate that power of attorney than others. Some states have very high standards. Some states just use a standard contractual standard. Hey, you have to be able to contract to be able to do this. In other states, I think some states have perhaps standards that are more akin to a will, where they have to have a base level standard, but it's not necessarily a contractual standard. It's a different standard altogether. So it's certainly it's different. And then I would note in Illinois, we do have what's called a short-term guardianship form, which has been interesting to watch come across the border. And I view this as kind of almost power of attorney-esque when you try to bring it cross border, because Sometimes people will accept it, and sometimes they won't. What the statute allows for here in Illinois, and this is more family law than the state planning, but what it does allow for theoretically is somebody could designate somebody to watch their kids for up to 365 days. And that is enforceable in the state of Illinois. It doesn't require any court intervention or anything, and it's freely revocable by the parent who grants that authority. And so one of the things that I've seen is sometimes people will execute those. They'll go, on vacation while their, Aunt Louise or whoever, right, watches the kids. And it's been interesting watching the interplay back and forth. A couple times we've had to make phone calls and go, hey, this is valid in Illinois. They're Illinois residents. You can take this. And it's an interesting set of problems. How do you deal with that? And there's no perfect answer, but that's something that we can do, kind of related to POAs, powers of attorney here. So it's certainly something that we can talk about. Let's turn for a second and talk about powers of attorney for school. So
Before we move on entirely, so for folks who are dealing like interstate a lot or who travel a lot, like what would y'all's suggestion be in terms of like best mechanism to ensure that power of attorney is going to be accepted wherever they're trying to use it?
That actually is one thing I'll talk about that I've seen a lot of is like Illinois. Florida is one I pick on a lot because Florida has very stringent standards on what they accept for an execution of a power of attorney. So like as an example, a lot of documents in Illinois only require one witness, which makes things really easy for an attorney that maybe is traveling to visit clients and things like that. But then if they take that power of attorney down to Florida, what ends up happening is you get a lot of kickback because Florida wants two witnesses and a notary on everything.
So does Georgia.
So what can happen is this is where I've been under the practice of, well, even if you're doing in Illinois, we're going to go above and beyond just to make sure that you don't run into that problem. So executing a will in Illinois or use a power of attorney, if you're executing that in Illinois, a lot of times it makes sense to use two witnesses and a notary because then when it falls on the desk of some company based out of Florida, they're going to look at that and go, oh, we're okay with this because you at least followed our procedures. But it's a good thing to know, especially if you travel to one specific state a lot, is knowing what their requirements are and making sure, let's say your Illinois or Iowa document is covering all of their requirements in that state, even if it's overkill in Illinois, just to make sure you don't run into that problem.
Yeah. Yeah, and I think Iowa's kind of the poster child for very different because they don't even require a witness on their powers of attorney. They can just do a notary. So it's it's
well, and even the revocation, you mentioned that earlier too. It's drastically different between states. Some require written revocation. Illinois, sometimes they'll accept it if the person, even if they have dementia, turns to the healthcare provider and says, I want to revoke this and I don't want this in place anymore. Yep. It all depends on this balancing of the rights of the person who drafted the power of attorney versus the person who was named. And they make it incredibly easy to revoke that power of attorney in Illinois.
Yeah, absolutely. And I think, the powers of attorney, as we draft them, it's certainly something that we consider, as we're adding powers or subtracting powers in and out of them. I think that's certainly something that we have to keep in mind. Now, as far as other things that you can do to make those powers of attorney more widely accepted across border is to have the attorney, if the attorney is drafting that, most attorneys will stick their contact information on there. And that's one thing we've gotten calls repeatedly over the years. Hey, is this a valid power of attorney? And what we say is, oh, well, let's check our file and see, why don't you send us what you have and let's take a look and we'll compare it. And we'll let you know if you've got the last one that we did, right? And what we can certify is, hey, we did that one. That's valid as of whatever date it was executed. And we've done that several times for folks whose parents moved out of state, or maybe they moved them closer because they were in a nursing facility. They needed to take care of them. And we've done that several times. And we've said, yeah, we've got a digital copy, this matches what we have in our file. That's not an issue. And we do that fairly frequently. And the other thing that can be helpful sometimes is medical facilities will say, hey, I don't recognize this, but if you get your lawyer to fax it to us, I don't know why that's a big deal, but they want it faxed, and they want it faxed from an attorney's office. And I maybe it's some weird thing in their state law. I don't know, but we routinely have people. We let our clients know, hey, if you ever want this faxed to a medical provider, if we've got a copy of it on file, if it's within our retention period, we'll be happy to fax it. So that's definitely another thing that can sometimes be very handy and be very helpful. Um, Actually, we had the VA once call us, and um, they had a patient who had dementia, and they had asked for a copy to be faxed. And I remember they needed the social security number on the documents. We had to, basically on the copy that was faxed so they could match it up. And I remember we had to put that social security number on, basically on a sticky note on the front, on a cover page. So that way they could match it up. So it's wild, wild what you see. So certainly something to consider. All right. Let's move on here to school powers of attorney. We just had a crop of students. They're heading out. We do these for people all the time. Maybe they want mom and dad to still help them with their banking. They want maybe to pay bills. Maybe they want some help, making those medical decisions. What options do we have? Any options for them? I mean, what are their options? I mean, do they need a power of attorney to get access to stuff, Ben?
Yes, they absolutely do. And that's once a child turns 18, the parents lose all legal right to all of that information. The HIPAA laws have been, adopted all the way across the country that technically any hospital isn't even supposed to tell you if they've admitted somebody if they don't have authorization to do so. And actually, there's quite a hefty fine. I believe the last time I looked, it was over 10 grand every time that they release information they're not supposed to. So, the hospitals really what they should be doing is not sharing anything unless they have written authorization to do so for anyone over the age of 18. So, where this becomes incredibly important, even from mom and dad helping out with a kid's checking account and maybe making a car payment for them or something when they're at school, a financial power of attorney can fill that gap. But again, the more important one I usually look at is the medical power of attorney in making sure when they get in a car accident or get admitted to a hospital somewhere, the parents have the authority to be able to get that medical information and help make decisions because they lose that power once the child turns 18. So, yeah, college time is definitely an important time to make sure those are done.
Yeah, the medical power of attorney is like especially important for student athletes too. I know I was on the varsity equestrian team, and there was a non-zero possibility that I would end up concussing myself. So yeah, I had a medical power of attorney when I was in college. The other thing too is like for colleges, like the FERPA laws, like there is sometimes it's not required, but if parents are needing access to any sort of school information, like they'd also need to get a FERPA waiver in order for the school to release that, or even to really talk to their parents. Like the schools typically won't even speak to parents unless they've got a FERPA waiver. So there are instances where it makes sense to also have that. Although if you don't want your parents in your business at school, like, it's a you call. It's not required.
Yeah, absolutely. And so let's turn to, we're going to spend the last few minutes here that we have. There's been a lot of chatter about Obergefell online. I know that there's a court case coming up. And people are concerned about, hey, what happens if maybe the Supreme Court overturns that decision, and we get suddenly a fractured set of jurisprudence on that. And what can be done there, and I'm going to turn to you, Steph, in our estate planning process and our powers of attorney. What kind of things can we do to help make sure that folks who are maybe traveling to states, and I will say in Illinois we have very friendly set of LGBTQ plus set of law that's very friendly to that. We have built-in HIPAA waivers in our and access rights in our powers of attorney. But what's different, in some other, in other ways that, maybe in Georgia or maybe other states that you can think of, and how would you approach, making sure that those rights of the agent are best enforceable?
Yeah, so in a state like Georgia that is not particularly LGBTQ friendly, I think about this in terms of like protecting that chosen family, and sort of preserving the rights that someone would have if they were married. So protecting the rights in the event that they go away. So something like the medical power of attorney, financial power of attorney, those protect to some extent. We also think about, like HIPAA waiver, hospital visitation for those folks. And the whole idea is to try to contractually create the rights that someone would have if their marriage was invalidated, if that makes sense.
Yeah, okay.
It's just the main thing of don't just rely on state law to cover it, because the default law does not line up with a lot of the non-traditional couples and that might be out there.
Yeah. And I think the same goes for, a lot of our unmarried couples that we have. I mean, even in Illinois, we don't have, there's no rights for a unmarried couple necessarily, unless you've documented that somewhere or somehow, right? So there's certainly a need to make sure that your wishes are clearly expressed ahead of time, and access is granted. That and perhaps, if for our frequent travelers again, people who may be traveling to other states, making sure that you've got, either a copy of your powers of attorney on you, or b, at the very least, some sort of short form card that says, hey, here's here's my agent. They'll have a copy of my power of attorney, making sure people have those powers of attorney available, so that way they can send those over to wherever. And I think some of the other things that we can think about as we're doing it is, as people are traveling, make sure that there is a clear set of communication between you and your family members, because just because you named somebody doesn't mean the rest of the family knows. So we need to make sure that they're aware of what your plans and wishes are, or at least who to contact, right? Because what we don't want to have happen is they call mom, and maybe you and mom haven't spoken about anything in the last 5 years, and mom doesn't even know who she's supposed to call. So sometimes just a letter might be a useful thing. You may not want to call her on the phone, but we would hope that the relationship is better than that. But sometimes reality is what it is. So that's where we're at. I think we're just about out of time. Steph, do you have any last thoughts that we should get through before we sign off for the day?
I do not.
All right. Ben, do you have any thoughts?
Just make sure everything's written down. That's the biggest thing at the end of the day. And it doesn't have to be complicated. You just want to make sure that it meets your state laws and what your needs are.
All right. Well, thank you guys for your time and consideration. I don't see any questions in queue, so we'll go ahead and hop off. Thank you for those attending in person, and for those who are watching later on. My name is James Greenwood. With me, I have Benjamin Young. Ben and I are both licensed in Illinois and Iowa. Steph Iasiello is licensed in Georgia. Thank you guys so much for your time, and you guys have a great day.